Welcome back. You're watching Daybreak on this 4th day of July 2023, and we are talking about that major decision that came from the courts yesterday. And before we took a break, we were talking about the importance of the CAS positions. And Honorable Sosion, when you reflect on what Honorable Elachi is talking about, making a case for slightly maybe we should have more cabinet secretaries. Well, it's unfortunate that you never really got to exercise your mandate because shortly after you were sworn in, you were required not to work. But from your background study that you've been able to do you associate with those views?
Very, very strongly. And not that I did not even exercise, but I served in education sector for long. And I saw what the Chief Administrative Secretaries, the value they came with to strengthen the administration and the deliveries of the ministry. I saw Elachi in her ministry. And we can agree there were gaps in the Constitution, of course, when the assistant ministers were removed and the public service was not reinvigorated to fill those particular gaps.
Right.
And this informed what was done. And you see, we are in 2023. The CSs in the previous administration served a full 5-year term. And there are facts, there are records and indicators. To administer a ministry and to deliver, the most important thing is delivering services.
Right.
It's an investment to deliver and to give value to services. So I agree very strongly with the experience and expertise of Honorable Elachi, having been a CS, that these positions are valid for purposes of strengthening the operations of state departments administratively. There's a big difference between the role of the cabinet secretary as the overall in charge of the ministries and a big difference of principal secretaries as accounting officers. Administration is a completely different domain, and these are not new. And I would like to rebut what my good lawyer here, Theuri, is trying to tell us about the ELRC case. The ELRC matter on the process of appointing the CSs mirrored very strongly on the Constitution. It mirrored. And because if really it was unconstitutional, then the ELRC code could not have entertained the matter. And Employment and Labor Relations Court, in its creation, has got equal powers with the High Court. That is how it's designed. And that matter was filed by Theuri. He did not challenge the outcome at the Court of Appeal. And that is a proper route to take. So it remains unchallenged to date. And therefore, there are a lot of untidy issues about this particular rule. Justice Mrema, Justice Mrema recommended regularization of the positions, which was never done. But look at the Kenya Kwanza administration when it came in. But there was a stay at the Court of Appeal on some of those. Yes, indeed, there was a stay to facilitate regularization by taking it through public participation and allowing the Public Service Commission to create the position, which was not done. Nevertheless, the CS are served full time. They did their job well. For me, from where I am, and as a labor leader, and someone who believes in efficiency of institutions in terms of service delivery, that was the best decision ever taken, and they served a full time. And when you look at what the Kenya Kwanza did, it did not hurry to appoint individuals. It revisited the ruling of Justice Mrema and tried to make and endeavored actually very strongly within the confines of the law and the Constitution to ensure that it was created by the Public Service Commission in a procedural manner and through public participation. And therefore, its creation has not violated any constitution.
But how, what do you say about, Honorable Sosion?
Yes.
And you're also waiting for the Senator of Bomet, who is joining us via way of phone. As soon as he's ready, we'll be speaking to him. But what do you say to the fact that The Public Service Commission had cleared creation of 23 positions, but the president created 50. And actually, even Justice Ongudi, that you say disagrees with the majority, is saying that 23 was fine, but this 27 was unconstitutional.
That is, it may be with that decision. Then, if you look at even the dissenting judge, it said she's saying 23 positions were legally established, and only the extra 27 were unconstitutional. Even if it was left there, then it would have been the best middle ground to deal with a particular matter.
Yes.
From where we are...
allow me, I'll get back to you. Let's first listen to Wakili Hilary Sige, who is the senator of Bomet. He's also an advocate of the High Court. Good morning, Senator. And specifically, the next move, especially for the government, at a time that you've suffered this blow, all the 50 termed to be unconstitutional, despite that minority decision by Justice Ongudi that 23 were constitutional, the majority of the bench says that everything is unconstitutional and therefore quashed. What's next? Senator Sige?
Good morning.
Yeah, good morning. Go ahead. I'm asking you about what next now.
I barely can hear you. I lost basically the bit that you were running through. There's a bit of heavy background noise.
Senator Sige, I'm asking you about, now that you've seen the decision by majority of the bench that the 50 positions are unconstitutional, what next for the administration?
Thank you, Sam. Thank you very much, and have a good morning. What is outstanding is that now, of course, are twofold. One, the decision has come from the courts. And remember, the Kenya Kwanza government, over time, from the time it ran its campaign up to the time it got into office, the conversation has been a government that is made,
sorry, Senator, I can't get you clearly. What do you say?
Yes, I was saying that the Kenya Kwanza is a government that is formed out of the rule of law. It will defend the rule of law in all its undertakings. One of the things that is going to happen is to comply with the orders of the court. The court pronounced itself yesterday. The government will comply with the court order. Remember, it also still has the opportunity to appeal against the decision. It definitely will. We are in the process of putting in relevant applications before the Court of Appeal. We desire to exercise that right as a matter of fact, and in the meantime, the law as it was pronounced by the court yesterday is going to be complied with.
Yes, you said that you're in the process of preparing your appeal at the Court of Appeal, but on what grounds that are different from what the judgment said?
There is a lot, Sam. It's unfortunate that I probably wouldn't be in a position to just run you through all of them for obvious reasons. One, of course, is the fact that, remember, though the majority of the bench declared the office of the CAS unconstitutional, the minority position has not only one or two of the grounds which you're going to appeal, but also, even in the majority side, there are certain part of the pronouncement that we are not agreeable with. And that way, we still have got now the opportunity to have the Court of Appeal pronounce itself also on the fact that there is an executive government that is formed. The Constitution under Article 152, 153, 154, 156 sets up the executive and gives us a number of the cabinet secretaries. It also gives us the number of, or rather the principal secretaries. It doesn't, however, deny the executive the opportunity to create positions that it desires in terms of the structure of running its government. And so there is a lot of fertile ground to appeal against the decision. And of course, we are very optimistic and hopeful that we will convince the Court of Appeal on the position that there is no unconstitutionality in the structure of an executive government that is elected.
And Senator, just lastly, even if you were to succeed in having the Court of Appeal agree with you that 23 positions are constitutional, how would you then choose out of the 50 who to remain, who to leave?
So you're saying out of the 60-40?
I'm asking you, even if you to succeed at the Court of Appeal that 23 are constitutional, how would you decide, or how would the President decide who out of the 50 would remain?
All right. Well, we're not going to be appealing against only 23. We are appealing against the entire judgment. We will definitely attempt to convince the Court of Appeal that we are entitled to have this number, that is the entire list of the CAS nominees. So we will not appeal on a piecemeal. We will appeal against the entirety of the judgment. And so our push will be to have the whole number, not only 23.
Okay.
All right. Yes.
All right. Thank you so much, Wakili Hilary Sigei, the Senator of Bomet. I have to let you go because you have to catch a flight out of Nairobi. But back here in studio, Honorable Sossion, you were making a point and I cut you short.
Yes, I was making a point.
Yeah.
You can see one judge dissented and stated that the 23 positions were legally established. But looking at the complement of the head of the public service in October, it requested for 23. And there was a further complement in February, that's 23rd February, requesting for 51. And that's aligning the positions to the state departments, because administrations and activities and efficiencies are domiciled in the state departments. And this position, yes, that is what it is. The second complement, why 51? The chief administrative secretaries will be domiciled at the state departments for purposes of administrations at the state department. That is what it is. And that's a fact for sure. You cannot run away from that. And therefore, the Public Service Commission was obligated to exercise its constitutional mandate to create those offices. And therefore, it did it procedurally. And in fact, I am not a lawyer, but where we are talking about breaching the Constitution, really a layman's interpretation, no clause of the Constitution has been breached. Positions have been created in the Public Service Commission in a very clean process. And if we talk about the role of the presidency, and allow me for purposes of sharing with Honorable Theuri here, is that the Constitution is clear that the president may perform any other executive function provided for in this Constitution or in national legislation, and except as otherwise provided for in this Constitution, may establish an office in the public service in accordance with the recommendation of the Public Service Commission, in accordance with the recommendation of the Public Service Commission. Monica Mbaru, who gave the ruling at the Employment and Labor Relations Court, must have consulted this clause very, very well. And therefore, this provision gives any president the mandate to create such offices, that notwithstanding, for purposes of efficient running of the administration and government. And so the issues of the question of constitutionality really here does not arise. Because these are positions being created. And today, and the positions may not necessarily be 23. If the president or if the Public Service Commission finds that maybe they need another 50 chief administrative secretaries for purposes of delivering. Because you cannot talk of cutting spending and you're not delivering. You see, input and output must be correlated. If you're putting resources that are not yielding much value to the people, then it's a loss. And so this thinking, which has been working over the last 5 years, precedent has been set, and Justice Mrima was right in his, and he applied his mind very well, that instead of abolishing these offices, I grant a stay so that it can be regularized to meet the threshold of the law and allow the Public Service Commission to do it. And I think that has been done. Okay. Listening to Counsel Sigei and any lawyer, any reasonable lawyer who is unbiased, will tell you that these three conflicting judgments, a square one in the Employment and Labor Relations Court that eventually created the 51 CASs, domiciled at the state departments of all government ministries, and the direction of Justice Mrima, and the ruling of yesterday. These are three conflicting judgments. And the ruling of yesterday lacks a lot of information in terms of government administration, government function, and is looking at CESs differently. And its reasoning is premised different. And I would challenge the URI. If really he still had issues with the creation of CESs, then he should have filed an appeal at the Court of Appeal immediately and instantly. But he kept quiet. He has not challenged up to date. And so, legally speaking and constitutionally
speaking...
Allow
me to circulate the question to the rest of the panelists, because you see, yes, you're saying that President Theuri did not appeal, but this was an active matter. I mean, this was a matter that was before the High Court, and the three-judge bench has made a decision. So we are dealing with a substantive decision also of the High Court.
No, in terms of timing, Gituku, so that we get things right. Because it's important we package facts for Kenyans.
Go ahead.
The Employment and Labor Relations Court dispensed of the application by the URI sometimes in November. And that matter rested. And that is why the Public Service Commission was mandated to proceed with the process. And these are the application at the High Court. These are the application at the High Court came up on the 17th of March. So really,
but he also
look at time span.
He also said that a constitutional issue has to be handled at the High Court, not at the Employment and Labor Relations.
No, that's not right. It's misleading. It's trying to mislead
tell me
the viewers.
What's supposed to happen?
All courts have powers, and the Employment and Labor Relations Court has jurisdiction to interpret whether matters are constitutional right or not. They have equal jurisdiction, and if indeed...
So are you saying this was the wrong court?
Yes, it's the wrong court, and it was in the wrong court, and we challenged the jurisdiction.
So what should happen?
What should have happened is that the matter should have been filed at the Court of Appeal.
No, I'm asking you, what should happen?
And appeal against the Employment and Labor Relations.
What should happen at the Constitutional Division of the High Court?
The matter, in fact, the URI and his group, if really they felt that it was the matter rested squarely at the Constitutional Division, they should have filed at the Constitutional Division. But it involves employment and creation of jobs. Employment and creation of jobs is a mandate of Employment and Labor Relations Court, which also is created by the Constitution.
Matters of constitutionality of decisions of the President and the Executive?
That rests with the Supreme Court.
Okay.
And the Supreme Court was created for that purpose.
I hear you.
But at the lower court, but at the lower courts, all the courts have equal jurisdiction to exercise their mandate.
No, the President...
So, but you see, right now, we have got three conflicting judgments. The
President will find you for calling High Court a lower court.
No, he's not going to find me. He's not going to find me. Because then, you know, I've been a very good user of the court.
That's a light note, Honorable Session. President Theuri, tell me, because I mean, there's all this confusion, and I heard the judges say that the fact that this CS position existed, it's a interlink between the PS and the CS, and saying that you have to have such a position created in a manner that is not lower than the position of a PS or even the position of a CS. When you look at what Wakili Sige is saying, that they are going to appeal against this decision to save the entire 50. From your view, because he said that if you asked a biased lawyer, I don't know they are biased. What do you think are the possible grounds of argument at the Court of Appeal?
I mean, I expect definitely the petition, the appellants, whoever they will be, to challenge first the question of constitutionality or unconstitutionality of the positions. I think that would be the main plank of the argument. You see, both the majority decision and the dissenting decision focused on the historical aspects that informed the proposal within the Constitution to limit the number of cabinet secretaries. So that is what is going to play out, I think, in my view, at the Court of Appeal.
Right.
And so therefore, my friend here, Sosion, should not really worry so much about the different interpretations as he seems to think they are, because quite rightly, the question of whether there are different interpretations is one which the High Court settled yesterday. Now, I think something that perhaps is lost, and Sosion may have the opportunity again to read the decision, is this, that the High Court found certain issues to be res judicata. Res judicata in the sense that res judicata is something that has already been determined by court. And so therefore the court ought not to hear that issue and determine it again. What was one of the issues that the court found to be res judicata? Is the question of the determination of the unconstitutionality of that office. So the court did not determine the question of unconstitutionality. It went by the Murima decision, which already found those positions to be unconstitutional. So whereas certain people are saying that there are 3 different decisions, the court has actually determined that point and said, no, we are not going to make a determination on the question of unconstitutionality. We are going by the Murima decision. When we went to court in the High Court, and even in the ELRC, the Murima decision is what you call a guiding decision. It's a decision which is given guidance on how the office ought to be established, which our friend here is calling the regularization of that office. One of the things which the court also said is the res judicata is the question of whether that office is of a stature of a state office that requires an enabling legislation so that it can be tabled in Parliament for adoption. Now, if you remember the advert that was put out by PSC, the intention was that after the competitive recruitment process, the names were to be submitted to Parliament for vetting. And that happened. And Parliament sent it back and said, there is no enabling legislation that would allow us to vet. For that reason, we cannot vet. And that is why they were hurriedly sworn in at 7 on 23rd, when a decision was being expected at 9, when the matter was being mentioned at 9 on the 23rd. But that is neither here nor there. So, and this is what should worry Sosion so much, that the decision that they sought to comply with, which is the Murima decision as government, has not been fully complied with, because there's no national legislation establishing this office. Now, when I hear Mheshimiwa here, and who served as a former CAS, explaining about the function of office, explaining why it is so important to have that office. That is everything that we all know about this office. And that is one of the issues that was being challenged. That this office is so high up there that the CS goes to Parliament for vetting. The PS goes to Parliament for vetting. This person is in between the CS and the PS, and it's not going for vetting. And that is why Murima said you must establish that office through an act of Parliament so that they can go for vetting, because it's a high-profile position. And I think Honorable Elachi here has confirmed. So the question then becomes, was there substantial compliance with the decision in Murima? There was none. Now, the final question which the court also determined was the question of public participation. Now, let me just give you what the Public Service Commission said, that it received about either 52 or 58% of the people who made representation before it said that that office is expensive to maintain. What did the PSC say? No. Despite the fact that more than 50% of the views that we've received from the public are saying that the office is expensive, we will nonetheless establish the office because there is a budget for it. No advice at that point from SRC, because the advice from SRC came this year.
And said?
So they had no advice from SRC whether they can be able to sustain that office. Remember,
what did that advice say?
The advice from SRC, what it did, it was actually not advice. What SRC did was to say this office should be paid 1 million. You know, this is the grading structure and whatever. Okay. But in terms of seeking advice on the effect of that office, the establishment of that office on the National Compensation Bill, that was not done. What did Murima say? Murima said that before you establish an office in public service, you must consult SRC on the effect of that decision on the National Compensation Bill. So was there compliance on that aspect? There was none. So it brings us then to the question.
Okay.
If the High Court says that you are supposed to do 1, 2, 3, 4, and you haven't done it, and a subsequent court comes and says, having looked at the decision in this is what you were supposed to do, and you did not do, you ask yourself then, which is this other decision that they are saying is conflicting? So all the decisions are actually on point.
Okay.
Both the Murima decision and the three-bench decision. But before I finalize, because it is also my duty to give information to the public with regards to what Mheshimiwa was saying, it's actually a wrong position in law with regards to the fact that the president can appoint advisors. And I want to point them out to the Public Service Regulation, Public Service Regulation, Regulation 27, which says that the Commission shall be responsible for the appointment of advisors to the President, Deputy President, and Cabinet Secretaries. So these are things that already have been done, because the President has been given his advisors, Deputy President has his advisors, and if they deem that they want to use this route then to go and perhaps bring in the CASs under the guise of advisors, then already there's the regulation in terms of how that is supposed to be done. And if it is done outside this regulation, then of course it's obvious what is going to happen next.
Okay, I hear you on the question of, because I remember reading that report by the Public Service Commission that 58% said that of Kenyans that made their submissions were saying that they didn't agree with the creation of the positions. But did the court talk about that? Because Justice Ongudi says that the public participation was sufficient. Did the court go into the nitty-gritties of what the percentages were? Because again, the views were not as much. They didn't even hit.
No, that was dealt with at the ELRC in terms of the response that was filed by the Public Service Commission to satisfy the court that there was a proper process of public participation. And
the court did not disagree or express themselves on the percentages?
The court did not express itself on the percentages.
Okay.
But what the High Court has done is to look at that report and say, if majority of the Kenyan people disagreed with the formation of an office, saying that it is expensive, how do you just say that because there is a budget, we can continue with this office? You ought to have consulted SRC on the question of, and that is why the High Court has said that the public participation that was conducted, essentially agreeing with the position that we took to the ELRC, that the information that has been given to the public was not sufficient to allow them to engage in meaningful public participation as is required under the Constitution.
Okay. I want us to listen, before we get to Honorable Elachi here, I want us to listen to former Senator Isaac Mwaura, who reacted to this decision while in court. Let's listen to what he said.
Sisi ni Wakenya kama wale wengine. Sisi pia tuna haki ya kushiriki katika mambo ya kitaifa. Tutakwenda katika mahakama ya rufaa na tuna uhakika. We are very convinced that we will be successful, because there is no way you can say that 23 are lawful and the others are saying 50 are constitutional. There is no way you can say that President Uhuru Kenyatta, who had 41 CASs, was right, but President Ruto, who had 50, was wrong.
Well, of course, he's an interested party, so it's understandable the reactions there. But Honorable Elachi, because there's all these arguments whether the president was right or was wrong, yet here we are. And consistently, the public participation question is becoming very critical in settling such decisions while in court. I mean, it was part of the breaking point of the Building Bridges initiative. It is now part of the breaking point in this particular issue. What lessons are we picking? And especially because Speaker Moses Wetangula said we do not have any legislation to facilitate vetting of these CASs. Would it have been more useful probably to take time and come up with that legislation, because there was no timeline on by which time those officers should have been in office?
You see, the best that we would have done after Murima's judgment, this is where we would have reinsured and did the correct process in terms of how you can now employ CASs. And I think Murima gave, suspending the judgment that we were already in office, all that, was giving space to government to ensure they regularize everything that he felt was done wrongly. Being a court of employment, one of the things you always know, that is a court where it will support employment. So there's no way you will ever find that court, unless there's something that you haven't done right. But that is a court of employment. And so it felt, yes, you need employment, yes, but you must follow due process. And so how I wish even now, Public Service Commission has now picked on this, looked at the ruling, and just try to reorganize their framework in how to deal with this going forward in future. Because if you go to the Court of Appeal, I wouldn't say whether you, let me not go, because they'll look at all the facts. They'll bring in the Murima, they'll bring in all this. And then they'll bring in the situation, how is it in the country? Because I don't want to argue about there is no money or there is money, no. You see, for me, and I always say one thing, you cannot say in public service there's no money, but when you are our lawyer in public service, you bring your own fee note. which can pay more than I don't know how many people, and that is one case you've done for us. It is wrong. So it's the same way. Money is not the issue. The issue is process. Does the president have power in terms of informal and formal? Yes. Informal is the executive orders. Do we follow through our constitution?
What do you mean informal?
There is formal. There is formal that is in the constitution, sir.
Okay.
Yeah. There is informal, that the executive orders. Those are informal powers that the president has. And that is why he gives executive orders. And we must accept that when we look at the United States Constitution, which we borrowed so heavily from, then it is time, most of us, because we end up following through, and then when it doesn't suit us, we come into a hybrid. If we really felt the United States, we have an executive presidential system, then there are so many things that the president can use this informal executive order to bring in clarity if he wants, or to even bring in issues that become law. And you can't question, because it is executive order and it is there. But then, going forward as a country, let us now appreciate that it is important, if you want to employ or to create a new position or designation that you would wish to do, first, you have to go through public service. They have the mandate. Then through public service will sit down with SRC, they will agree. If they agree, then now you ensure follow due process, public participation has to be there, and then now you bring it for approval in Parliament, and you get this thing right. And I'm hoping we can do that way, the right way.
Let me ask you, what do you think of public participation? How far should it go? Because
well, for me, in employment now, I find it not fair to tell me what public participation. I thought when I am being...
Is it a question of employment, job opportunities for a few Kenyans, or is it a question of creation of an office to serve?
Well, I don't know what is a few Kenyans. A Kenyan is a Kenyan. Whether he's a daughter of a president is a Kenyan, Sam.
No. And 50 versus 50 million is a few Kenyans.
No. The Kenyans who apply will not be 50. The Kenyans who will be... It's the same way, the way we do all this employment. I don't know. I know this one is very political. That's why we look at it. But look at the portal of public service. How many jobs are there? There are so many. But how many will be picked? Maybe 12, maybe 11. Has anyone ever questioned? And those are directorships. For example, you see why I'm feeling very disappointed? How come the lawyers went for this CAS? But how come the president has been removing and quashing, revoking all the boards of directors, whoever went for them to court? Was it right? Their contracts were still on. There were contracts. They were still on. Yet he could not wait. But because he used the executive order, that's why I'm telling you, he has that informal power. But no lawyer felt all these directors who were supposed to finish 3 years could not be, even one person could not question, why are they just being removed? Their gazette notice being quashed.
You're losing me.
I'm not losing. I am giving you, I am telling the lawyers, if we want to look at all these things, let us look at it in a proper way, in a manner where even those who have been revoked their contracts can feel, we also deserve. But you see, they were just revoked. Nobody questioned. We gave the president, who has the executive power. And so I don't see why we are concentrating on this, yet we could not concentrate on that other political animal where more than, I think, if I'm not wrong, 2,000 people have been, their contracts have just been revoked like that.
Okay, look. Two different issues. First, you're talking about...
I was giving you an example so that you see both animals are the same. It's only that the feeds are different.
You're talking about board members.
Yes.
And chairpersons.
Yes.
Those are positions that exist in different statutes.
Yes.
And people are appointed to those positions, most of them to serve for a period of 3 years.
Exactly.
But that appointment can be revoked by the appointing authority without any notice, which has happened.
No. The law does not say without any notice. No.
Sam, I think
the law is very clear also on that.
I think
let me go to the lawyer then.
I think Mheshimiwa here is just being a politician, throwing a spanner into...
No, I'm not being a politician. I'm just being honest on this matter.
Let him express it.
There have been several cases where appointments have been challenged. I know for a fact that we already as a society are working on one or two others in terms of where we feel that the power has been invoked in a manner that defies statute. We have a number of decisions that have been made by ministers appointing acting CEOs or CEOs and whatever, which have been done in contravention of the law. And those have been challenged. But I just wanted to say that we are not selective in terms of where we train our guns on, so that...
Yeah, I wanted us to finish on that point. Sorry,
yes.
I'll get to you, Honorable Sosion, because you, first of all, took issue with my statement that a few Kenyans.
Yeah.
So let me say, creating positions...
There will be always few, sir.
Is this a question of creating employment for 50 Kenyans, or it's a question of creating positions to serve Kenyans? Because I think what the High Court was saying is that you're creating 50 positions. If the Constitution, the framers of the Constitution wanted to create 50 deputies, they would have done so. If they didn't, then there's a procedure that must be followed if you're saying that the president has power to create an office, which has not been done. And that is all, my specific question, the central question was on the public participation. How do we measure that?
And that's why I said it will be very difficult in terms of measuring public participation when you're doing employment. You see, it is not, in this employment, I don't know how you will want, not you, I don't know how now the courts or the lawyers would want to see and give a percentage that if, for example, we have, let's say, the same judges, see, they are being employed, for example. So how many will apply, and they go through their process, and Judicial Service Commission finishes? Do we normally question that public participation? It's so difficult because they go through their Judicial Service Commission. The same way with Parliamentary Service Commission. You go through that process, you might have 1,000 people who applied, but you'll only pick 3 or 4 among those. And so the question then goes again, what about if an institution would wish to do internal? So will you question that public participation? That's another thing we should ask ourselves, because we might have internal jobs for people who have been within an institution and they qualify, but you must take them through that internal process for them. And you have your, and the other question should be now, each institution has their human resource manuals that guide processes of how you deal with HR, how you deal with employment. So do you want to say now they will disregard this and we just go on this public participation is another question. So for me, the best and so that we deal with this matter, for example, the CAS one, is can Public Service Commission now deal with the process until the end, create all the frameworks that are needed, where read the judgment of the judges and go through it properly, and now create that process. But you must take this to public participation maybe, because you are now creating a framework. And it has to be approved maybe by Parliament before now you come now to your recruitment and all that. Maybe that is what the courts would wish to see, or the judges, according to their ruling. Maybe that's what they were questioning. Can you take it through a process where it is approved in Parliament, and then now you come to your...
I hear you, Honorable Elachi.
Yes.
Honorable Sosion, so how do we move from here, especially knowing, like I said, that Speaker Wetangula said there's no framework for vetting. So even if you had been cleared to take office, it would have happened without parliamentary vetting because of the absence of a legislation. So who should...
I think some of these hanging questions like the one you're asking will find solid answers with time. you've asked, 50 positions are being created for people or to serve Kenyans. 50 positions have been created in accordance with the Constitution and the law, particularly Public Service Commission Act, Article 27, to ensure efficiencies and good administration at the state departments of our ministries. That is what it is. So all of them are correlated. The questions of whether SRC was involved, you see, it's neither here nor there. When the employment court gave the green light, then indeed there was no objection from SRC, and all these bodies have given in their submissions, and none has indeed objected. I want to say very clearly here, so that you don't, we don't mix the role of the minister and that of the principal secretaries. It is wrong to impute that the CASs are deputizing ministers. No, that is wrong. It's completely wrong. The ministers are created by the Constitution, and their role is distinct. It's spelled out in the Constitution. They don't have deputies. The permanent secretaries are created. They have their role, and they don't have deputies. It's very distinct. And the Public Service Commission Act, Article 27, has created chief administrative secretaries. The question that Mrima asked has been asked and has been executed through the Public Service Commission. And indeed, Speaker Wetangula was right. If the Public Service Commission, and these are officers covered by the Public Service Commission Act, then they cannot be vetted by Parliament. Those to be vetted by Parliament are and the Constitution is explicit, the CSS and the PSS. And so this office that was created is properly codified by the Public Service Commission Act. And what the Public Service Commission did from the beginning to the end, created it. And if we question the constitutional mandate of the president to create offices, it's spelled out in the Constitution. And those powers are assigned to the president to create offices only in accordance with the recommendation of the Public Service Commission. This has been done. So I would say the litigants, the litigants who are political litigants in the Employment and Labor Relations Code, and in the Mrima case, because they didn't find ground, shifted to forum shop in another court, which is okay, but has been indicated by some lawyers, this matter, when it goes to the Court of Appeal, they will be distilled and clarified. And those who will not be satisfied can still move to the Supreme Court. So it is good we have got a judicial framework in this country that any citizen seeking for justice will always get. If you are not satisfied with the rulings of the lower courts, you can always move to the Court of Appeal. If you are not satisfied, you can always move to the Supreme Court. But I can say 90% from where we are, or 100%, with this question that people don't have clear answers. I think Kenya Kwanza government, the president and the Public Service Commission and the entire government have really endeavored to absolutely comply with the provisions of the law in creating these offices. For purposes of administering, for avoidance of doubt, for purposes of administering operations of state departments, but not to deputize the cabinet secretary. That's wrong. It's wrong for Theurian group to try and create a non-existent framework in government. That CSs are deputies of ministers. I know, and I knew if I walked to that office, my business will be to administer the state department.
Well, you know, you associate yourself with Mrima decision, but you're also questioning why CSA should be vetted, and the Mrima decision said that they have to be vetted. So there's a bit of inconsistency there. But all the same, this